hatol ko. Ang nasasakdal na punong mahistrado ng Korte Suprema ay hindi na po karapat-dapat sa pagtitiwala ng sambayanang Pilipino. Mr. President, I vote to convict the accused Chief Justice of the Supreme Court. Maraming salamat po.
Secretary.
Honorable Senator Judge Honasan.
To our countrymen, my fellow Filipinos, Mr. President, distinguished colleagues, honorable members of the prosecution and defense panels. From the beginning of this trial, I have been looking for a reason to acquit. Based on compassion, based on the basic precept that a man is innocent until proven guilty beyond any reasonable doubt, and based on my own personal experience. I know what it is like to have my family maligned and to be deprived of due process. That being said, this trial is not about personalities, emotions, or partisan politics. This is about judging whether the highest magistrate in the highest court of the land is fit for the job. Is his integrity beyond any doubt? Is his understanding of the law absolute and beyond question, as the position demands? At every moment in his legal career, did he speak out against injustice and uphold the law, rising above us all? An institution is only as strong as its leader. And we, senator judges, are only extensions of the will of the people. We have gone through the process to bring us as close as possible to certainty. It is my opinion that we have not proven if the defendant is corrupt or if he is malicious. What is clear is that based on the doubt cast on his capability to dispense justice and to do his duty, he is no longer fit to preside over the highest court in the land. Ang malinaw po ngayon ay may duda na sa kakayahan ng ating punong hukom. Doubt is the opposite of faith, and faith is the source of hope. Doubt does not happen in our brain, where reason lives, but in our hearts, where our moral compass rests. I vote to ask the Chief Justice to step down from the pedestal where he was installed by the nation and where he was supposed to preside over the highest court in the land, so he may once more walk among our people, where all public officials must be judged. Bumalik na siya dito sa atin, sa piling ng taong bayan, para maranasan niya ang bunga ng kanyang pagkukulang. Sambayanang Pilipino, ang hatol ko po ay guilty. Mr. Chief Justice, I wish you strength and honor. Thank you, Mr. President.
Honorable Senator Judge Lacson.
When a witness takes the stand, he swears to tell the truth, the whole truth, and nothing but the truth. That makes half-truths no better than lies. I have always been an investigator all my public service life. Modesty aside, I have the uncommon ability to determine if a person is telling the truth or not. An error in judgment has no place in this trial because it is final and irreversible. Equally important to me is the testimony of the respondent, particularly in this case, because the exalted position of the highest magistrate of the land must shut its door to anyone who desecrates the solemn oath that engulfs a testimony in any judicial proceeding. Over the weekend, I did my homework and discernment. Let me share it with you. Chief Justice Renato Corona at one point had $3,977,790.87. At a given time, he had 91,280,499 pesos and 22 centavos. If you ask me, so, what is the difference between 3.9 million and 2.4 million US dollars? Between 91 million pesos and 80.7 million pesos? My answer is a lot of money. Chief Justice Renato Corona used to work as a senior officer of the Tax and Corporate Counseling Group of the Tax Division of a prominent accounting firm, Sisit, Gores, and Belayo and Company. He also taught commercial law, taxation, and corporate law at the Ateneo de Manila University for 17 years. I find it hard to believe his testimony that he does not understand accounting. Chief Justice Renato Corona testified under oath that he invested in currencies and not in properties in the late 60s, mindful of the Basa Guidote family squabble over some real estate properties left by their deceased parents. The fact is, the family feud started in 1989. One cannot simply learn from the lessons of the future. Even if the standards of moral fitness for such a lofty position in government were lowered, an acquittal may still be difficult to justify. Mr. President, distinguished colleagues, I therefore find the respondent guilty as charged under Article 2 of the Articles of Impeachment.
Secretary.
Honorable Senator Judge Lapid.
Hi, Mark. Magandang hapon po, Senate President. Kasamahan kong Senador, Judge, Prosecution, at Depensa. Sa ating mga kababayan nanonood at nakikinig sa TV at radyo, inuulit ko magandang hapon po sa inyo lahat. Alam niyo po, wala man po akong speech dito. Wala po akong dala. Yung mga kasamahan ko dito, pag pinasok sa isip nila, dadalhin sa bibig at maganda na ang sasabihin. Bilang high school graduate po, sa ating mga kababayan, anong sasabihin ni Lito Lapid na hindi marunong mag-English, na hindi kaalam sa batas? Ano kaya ang magiging desisyon? Didesisyonan po ang kataas-taasang hukom ng isang high school graduate lamang na tiga probinsya ng Pampanga. Napakinggan ko po ang depensa. Siguro purihin po natin ang depensa. Napakagaling nila sa mga nakakaintindi ng mga abogasya. Purihin din po natin ang prosecution. Naghanap ng mga ebidensya. Nakinig po ako sa bawat ebidensyang inaano nila dito. Ngayon, naayon po, lalong-lalo na si Congressman Pariñas, yung pong pinirsinta niya kahapon dito, para sa akin lang po, ay malinaw na si Chief Justice Corona ay lumabag sa batas. Siya mismo inamin niya na may $2.4 million at 80 million pesos na bank account. Yun po siguro hindi na kasinungalingan yun. Yun po ay totoo na. Nagpipresenta po ako dito hindi bilang abogasya. Hindi po ako pwedeng magsalita ng Republic Act dahil hindi maniniwala ang tao sa akin. Hindi po ako nagmamarunong-marunong dito. Ang ginagamit ko lang po dito, konsensya. Representante ng masa na hindi nakapag-aral, hindi marunong mag-English, ni walang alam sa batas. Kaya, nung pong nagsasalita dito, si Chief Justice Corona, nagsusumbong sa taong bayan. Awang-awa po ako sa kanya. Akala ko totoo sinasabi niya. Hindi pala. Mas pinaniwalaan ko pa si Congressman Pariñas nung nag-PowerPoint dito. Ngayon, ang sinasabi niya ay isang pizza pie. Hindi po totoo yan na may 82 akong account. Siguro kung ako ang pagbabasihan ko, kung 100 basong tubig linagay sa 4 na drum lang ang kanyang account. Naawa po ako sa kanya dahil naintindihan ko po kung anong damdamin niya at sa kanyang pamilya. Nararasan ko rin po yan. At sana pagkakataon ito, pasasalamatan ko siya. Dahil nung pangalawa kong panalo bilang senador, sa kanya ako nanumpa bilang isang senador. Pasensya na po. Pasensya na po. Ang hatol ko sa inyo, guilty.
Honorable Senator Judge Legarda.
Please maintain decorum in this court. We do not want to be disturbed.
Mr. President, sambayan ng Pilipino, hindi po madaling humusga ng kapwa, lalo na kapag ang nasasakdal ay ang punong mahistrado. Mahirap pong humusga sapagkat tayo ay tao lamang. Ngunit ito po'y isang sagradong tungkulin na ating dapat gawin. It is a sacred mandate I must keep. And I do it in all honesty and sincerity, without anything in exchange, without bending to any perceived pressure, but born out of intensive study, contemplation, and prayer. Mr. President, while we ponder on the 3 articles of impeachment, the most robust documentary and testimonial evidence and debates have centered around Article 2. I therefore select Article 2 as the anchor of my verdict because I hold that public and truthful disclosure of assets, liabilities, and net worth by a public official is a key and fundamental element of governing through the norms of transparency and accountability, and a centerpiece principle of democracy. Disclosure of SALN is the only window by which the public can judge whether or not we have undeservedly enriched ourselves in public office. Through it, we, as public officials, earn public trust. Public trust is not simply an administrative entitlement by those in government. Mr. President, I am disappointed that concessions of disclosure of SALN and the waiver of bank secrecy have only been belatedly and calculatedly done when these have been rendered moot by the practical turn of events. I also believe that interpretations in the wordings of the law should not obscure the charge of betrayal of public trust supported by evidence. For public trust is earned through transparent, often voluntary gestures of honesty by officials in question, and not solely by legal argumentation, no matter how sophisticated. In casting my vote, Mr. President, my chief concern is the credibility and the trust of our people in the most important institution of our land, whose mandate is to interpret the law and render wise and fair judgment equally to all. Sa dinami-rami po ng mga argumentong legal, ebidensya, at pati na po ng napakaraming PowerPoint presentations na inilatag ng prosecution at ng depensa sa paglilitis na ito, isa pong kaso na hinatulan ng Korte Suprema noong 1997 ang tumawag sa aking pansin. Ito po yung kaso ng isang kawani ng hudikatura, isang interpreter sa Regional Trial Court na siyang tinanggal sa serbisyo dahilan sa hindi niya nadeklara ang kanyang negosyo sa palengke sa kanyang SALN. Ginoong Pangulo, kung ang ating mga batas tulad ng Republic Act 6713 ay nagpaparusa ng dismissal sa isang ordinaryong kawani ng gobyerno sa paglabag ng mandato upang maiwasan ang katiwalian, wala po akong nakikitang dahilan para po hindi ipatupad ang parehong batas na ito sa isang punong maestrado. Mr. President, we are all guided by the basic principle of equal application of the law. And in Thomas Jefferson's own words, and I quote, "It is certainly for the good of the whole nation to deal law and justice to all by the same rule and the same measure." If we acquit the Chief Justice, we would tragically lift the floodgate for public suspicion and widespread distrust on the highest institution of our judicial system. We also lower the bar of public accountability of government officials. It was not easy. It is painful, but we must do it. I therefore vote for